Alright, 501c14 credit unions and other mutual financial organizations. Alright. If your organization wants to be obtained the recognition of exempt in the credit union with capital stock organized operated under state law, for mutual purpose without profit, they must file an application includes facts and information attachments described in section. Additional show the following procedure. Following application described in application procedure chapter 1. Federal credit unions are organized operated with the accordance with the Federal Credit Union Act as amended with the instrumental with the United States, therefore exempt under the section 501c1, included with a group exemption letter issued to the National Credit Union Administration. They are discussed in this publication. State chartered credit unions, other mutual financial organizations file application for recognition exemption. Federal income tax under 501c4 of the other mutual financial organization must corporations, the association without capital stock organized before September 1st, 1957, operated with a mutual purpose without profit to provide pre-reserved funds for the insurance of the shares of the deposits. Domestic Building Loan Association, cooperative banks, and without capital stock organized operated with a mutual purpose without profit. 3 mutual saving banks not having capital stock represented by shares, and 4 mutual saving banks described in section 559 591B. Similar organization formed with the September 1st, 1957, provided with the reserve funds, but not necessary insurance with the share of the deposit in one of the type of the savings. The institution described in 1, 2, and 3 above the exemption tax is 85% more of the organization income that provided with the reserve funding for the investment. There is no specific restriction against the issuance of capital stock for these organizations. Building a loan association, saving loan association, mutual saving banks, and cooperative banks other than described in this section are exempt from the taxes. However, certain corporations organized and operated in conjunction with farmers cooperatives can be exempt in section 521. Application: the IRS does not provide prevented application for the form used for the organization described in this section. The form written application is acceptable as long as it shows information indicating the section whose declaration that it is made under the penalties and perjury. The application must be submitted and duplicated. State chartered credit unions. Your organization must show the application of the form under the state credit union law and the state and date of the incorporated. The state and credit union law is respective of loans, investment, dividends, if any, become complied with. A form of state furnished with the application of credit union National Association acceptable meeting application requirements of credit unions, and all may be used instead of the statement of application just described in the following reproduction of that form. Claim exemption for the date, federal income date, blank date, with the undersigned by the complete name, blank complete name, credit union, complete address, and include street number, credit union operating under the credit union law states under the blank claims exemption of the federal income tax applied the following information relative to the operation. Date of incorporation blank. It was incorporated with the credit union law state of blank and is being operated under the uniform bylaws adopted by said state. 3. Making loans state credit union law requirements, including for the purpose of the Secretary of the rate interest in charge thereon, are complied with. Investment are limited to securities which are legal investments and credit unions under the state credit union law. 5. The dividend share, if any, with the distribution with the prescribed with the state credit union law. I understand the duly authorized officer the blank credit union incorporated declares the amount of information, true statement of facts concerning the credit union, signature of blank officer, title blank. Other mutual financial organization. Either organization included with the section must show for the application of the state with which the organization incorporated with the date of the incorporation, the character of the organization for the purpose of which it was organized, the actual activity source of the receipt, disposition thereof, whereas any of the income may be created in the surplus, may be benefit any of the private shareholders and individuals where the law relating loans, investment, and dividends is being complied with in general with all facts relating to operation and effect of the rights exemption. The application must include the detailed information showing that there is an organization provided with most both reserve funds and issuance of shares deposits of the members' financial organization, or the organization provides reserve funds for share deposits for the members, and 85% of more of the organization income provided with the reserve funds for investment, that they should be attached a confirmed copy of the Articles of Incorporation and other documents saying with the permitted power activity of the organization, the bylaws, the other similar codes, regulation, latest annual financial statement showing the receipt and disbursement, assessment, and liability of the organization. 501c Veterans 501c19 Veterans Organization. A post-organization of past present members of the armed forces of the United States must file the Form 924 of the apply with the recognition exemption federal income tax. You should follow the general procedures outlined in Chapter 1. The organization must also meet the qualifications described in this section. Example of the group qualified with exemptions are most auxiliary American Legion veterans, foreign wars, Similar organizations qualify recognition exemption, but the application should show the proposed organization organized in the United States any possessions and that at least 75% of the members, the past and present members of the U.S. Armed Forces, then at least 97.5% of the members of the organization are past and present members of the U.S. Armed Forces, cadets, including only students in college or university ROTC programs, or armed service or at armed service academies, spouses, widowers, ancestors, lineal descendants of any of those listed here. 3. There are no part of net earnings inure the benefit any private shareholder individual. In addition to these following requirements, a veteran organization also must be operated exclusively and for one or more of the following program purposes: promotion social welfare community that is promote in some way the common good of the general welfare of the people of the community, to assist the disabled, needy, war veterans, and members of the U.S. Armed Forces, the dependents of the widows and orphans of the deceased veteran, provide entertainment, care, and assistance for the hospitalized veterans or members of the U.S. Armed Forces, to carry on programs perpetuate that memory of the deceased veterans and members of the armed forces, conform their survivors. 5. Conduct the programs of religious, charitable, scientific, literary, educational purposes, to sponsor, participate in activities of patriotic nature, to provide insurance benefits on the members and dependents on the members of the both, dependents of the members or both, to provide social recreational activities for the members. Are an auxiliary unit. Auxiliary unit Society Veterans Organization can apply with the recognition exemption and provided with the Veterans Organization parent organization meets the requirements expanded with earlier in this section. Auxiliary unit of the section must meet all following additional requirements: affiliated with the organization in accordance with the bylaws, regulations formulated with the parent organization. At least 75% of the members, either past or present members of the U.S. Armed Forces, spouse of the members, related to those members within 2 degrees of the kinship of the grandparent, brother, sister, and grandchild, and represent the most distant allowable relationship. All of its members, either the members of the parent organization, spouse of the member of the parent organization, related with the member of such organization with a 2 degree of the kinship. No part of their net earnings inure the benefit of any private shareholder individual. Trust or foundation. Trust or foundation veterans organization also can apply with the recognition exemption provided, but the parent organization meets the requirements exemption explained earlier. The trust foundation must meet all the following qualifications. The trust fund existence under the law and local laws organized for the charitable purpose. The solution provided with a similar charitable organization. See articles in organization in Chapter 3 of this publication. 2. The corpus income cannot be diverted unless other than a funding of the veteran organization described in the section religious, charitable, scientific, literary, educational purpose for the prevention and cruelty of the children or animals. Insurance is set aside. The trust income unreasonable accumulated if the trust or foundation is not insurance is set aside. Substantial proportion of the income is in fact distributed to the parent's organization for the purpose described in item 2b. If organized exclusively for one or more of the purposes listed earlier in the section that are specifically applicable to the parent organization. Tax treatment, donation, war veterans organized deductive charitable contribution to donor federal income tax return. At least 90% of the organization members must consider the war veterans, and the term war veteran means person whether or not present members of the U.S. Armed Forces, whether served the U.S. Armed Forces during the period of war, including Korean Vietnam conflicts of the Persian Gulf War and later declared wars. 501c21 Black Lung Benefit Trust. The organization wishes to obtain the recognition exemption of the Black Lung Benefit Trust. They must comply with the application letter and include with a copy of the trust instrument. The general procedure filed with the obtaining a recognition was discussed in Chapter 1 of the publication. The section describes the additional or specific information provided upon application. Requirements of Black Lung Benefit Trust that is established, writing, created with the organization of the United States or contributed to by any of the person except the insurance company will qualify the tax exempt status if it meets the both following requirements. The trust must be irrevocable, that there can be no right or possibility of reversion of the corpus income of the trust of the coal mining operation or other creator. Exempt, the creator may recover the excess contribution. Its only purpose is to satisfy the whole in part of the liability of the person generally of the coal mine operating contributing with the trust or for which the respective claims compensation arising federal, state statute, the disability of death due to pneumoconsciences. To pay premium for the insurance to cover the over on the liability to pay administrative or other incidental expenses of the trust, including legal accountability, accrual, trustee expenses in connection with the operation of the trust and processing black lung claims against such person arising from federal and state states. To pay accident and health benefits, insurance premium, and other administrative expense for the retired coal miners, their spouse with the amount of the assets available to First Electric General Limited, 110% of the present value of the limited liability black lung benefits. 2. No part of the asset can be used as verdict, if any, with a purpose other than the purpose of describing 1. Payment of the Black Lung Disability Trust Fund and General Fund by the U.S. Treasury, other than satisfaction of any tax or other civil criminal liability of the person who established the contributed trust. Investing public debt security for the U.S. obligations, state, local government that are indeed to hold with the principal, interest, time, and demand of the deposit bank and the insured with the credit union local located in the United States. The investments are restricted to the extent of the trustee determination of the portion of assets and which needed for purposes described in 1. Annual information return and required as exempt as described in Section 501C 24.1, Form 990BL, information and initial excise tax return for the Black Lung Benefit Trust and certain related persons must be used for the purpose of the trust normally with the gross receipts of each year of the tax share no more than $50,000 and expect the following requirements. However, they must be submitted an annual electronic mode form, the 990N. The e-postcard. Excess tax. See Chapter 5, Information on Excess Tax that may be imposed on the organization. Tax treatment, donation, contribution taxpayer generally on the coal miner operated with the Black Lung Benefit Trust, the deductible federal income tax purpose under Section 192. Deduction is limited to any excess contribution with subject to the excess of tax 5%. 69 return of excess tax on excise contribution with Black Lung Benefit Trust and under Section 4953 and computation Section 192 deduction is used to compute allowable deduction of any of the excise tax liability. The form does not have to be filed that there is no excess tax liability. For more information about these contributions, see the 6069 in its instructions. Alright, 501c. 501c2, title holding corporation with single parent corporation. If your organization wants to obtain recognition exemption with the federal income tax for the corporation or desires to hold the property collect the income of the property and turn over the entire amount of less expense for the single parent organization exempt the income, the must apply application for the Form 1024. The information submitted using the application described in section. This section for decision of the procedure of obtaining recognition for the exemption and see Chapter 1 Application Procedures. I'm going to show the organization and the corporation that if you're in doubt is whether the organization qualifies in the corporation purpose to contact IRS office. Title holding corporation qualifying exemption only over the effect of the ownership of the control of the distribute exempt organization. For example, the distribute organization may control the title holding corporation by owning voting stock, possessing power with the selecting nominees to hold the voting stock. Right, corporate charter. The corporate charter confined for the purpose of the power of the organization to hold and title the property of the collecting of the income from the property, turning the income over the exempt organization. If the charter authorizes your organization to engage actively to go beyond these limits, the exemption may not be recognized even if the actual operations are so limited. If the organization's original charter does not limit the powers, you can amend the charter and conform with the required limits to submit evidence whether your application with the charter has been amended. The payment of the income, you must show that your corporation is required to turn over the entire income from your property less expensive one more of the exempt organization. Actual payment of the income required is mere obligation for the use of the income with the exempt organization benefit in the fact that such organization control over the income debt that satisfy the equipment. Expenses may be reduced the amount of the income required to turn over the tax-exempt organization which organization holds the property. Determine expenses for the purpose includes not ordinary necessary expenses paid or incurred, but also receive additions, depreciation reserves, other reserves that would be proper for the business corporation holding title to maintain property. In addition, the title holding corporation can retain as part of its income each for the year to apply the deduction of property with which it holds title. This transaction is treated with the income have been turned over to the exempt organization to later leave the income to make the contribution with the capital title holding corporation. The turn earning applied with the contribution and debt. Waiver payment of the income. Generally, there is no payment of the rent with the occupation of the property held by the title holding the corporation exempt the organization for which the corporation holds the title. In this situation, the same requirement that the income must be paid over to the exempt organization satisfied when the corporation turns over whatever income is available. Application recognition exemption. In the addition to the information required for the Form 1020 for the title holding corporation furnished with the evidence for the organization with the title of the help of the obtaining with the recognition of the exempt status of the organization has been specifically non-withheld the writing of the IRS exempt the title holding corporation must submit with the necessary application supporting documentation to enable the IRS to determine whether the organization over which the title is held the qualities exemption. A copy of the ruling determination letter issued by the organization for which the title is held will be proof of the qualifies exemption. However, until the organization which the title holds obtained the recognition exempt status, the proof of the submitted to show the quality applies, the title holding the corporation can be obtained recognition of the exemption. Tax treatment, donations to an exempt title holding corporation generally are deductible as charitable contributions on the donor federal income tax return. Alright, 501c25, title holding corporation with a trust and mutual parent corporation. If an organization wants to obtain the recognition of the exemption federal income tax, the organization organizes exclusive purpose of the acquiring holding title with the collecting income for the real property, turning over the entire amount with less expense for the member of the organization that exempt the income tax. It should be filed with the application form 1024. Discussion of the procedure obtaining the recognition of the exemption. See Chapter 1, application procedures. Who can control the organization? Organization required to have an exempt in the section can have up to 35 shareholders. The beneficiaries in contract with the title holding organization recognized exempt in section 501c2, which can have only one control parent organization requirements. A 501c25 organization must either be either a corporation or a trust. Only one class of stock permitted in the case of the corporation. In the case of the trust, is only one class of beneficial interests allowed. Organizationally eligible to acquire holding interest. The type of the holding organization is qualified person profiting, sharing stock of bonus plans, governmental plans, government and their agency instrumental with a charitable organization. The articles of incorporation, trust, and instrument must include the provisions showing that the corporation of the trust is organized to meet the requirements of the statute, including compliance with limitation membership classes of stock and beneficial interest, the compliance with the income distribution requirement of the organization. Documentation must permit organization shareholder beneficiaries to dismiss the organizational investor and advisor if any of the upon the vote stakeholder shareholders or beneficiaries hold the majority interest of the organization. The organizing document must meet the shareholder beneficiary to terminate the interest by at least one of the following methods: by selling exchange for their stock of the beneficial interest of the organization described in Section 501c25c, provided this sales exchange does not cause the number of shareholders or beneficiaries to exceed 35. By having their stock of the beneficial interest redeemed with the 501c25 of the organization up to upon 90 days of the notice. If the state law prevents corporation from including articles in corporation above the provisions, such provisions must include the including bylaws of the corporation. A 501c25 organization can be organized as a non-stock corporation, and the articles of incorporation bylaws provide the members have the same rights as discussed below. Subsidiary as a whole owned subsidiary won't be treated with a separate corporation as all assets, liabilities, items of income deduction credit will be treated belonging to the Section 501c25 organization. Subsidiary shall apply the separately recognition exemption. Tax treatment, donation exempt status of the holding corporation generally aren't deductible charitable contributions for the donor federal income tax. Unrelated business income. Unrelated business income. Generally, the receipt of the unrelated business income to Section 501c25 organization will subject organizational law to exempt status, since organization can be exempt from the taxation and engaged within any of the business other than holding the title of the real property, collecting the income from the property. However, the exempt status generally won't be affected by the receipt debt finance income, but the treated unrelated business tax income solely because of Section 514. Under Section 514c9, certain shareholders' beneficiaries are subject to the unrelated debt and finance income tax. Under the Section 514, their investments through organization, their shareholders, generally schools, the college, the university, supporting organizations such as educational institutions, organization other which will take into account with the gross income, unrelated trade business, the prorated share of the income, and the treated with the related and finance income. Because the 514c9 does not apply, the organization will also take their prorated share of the allowable deductions, unrelated taxable income. Real property, including the personal property listed in connection with the property, but only if the rent of the personal property is more than 15% of the total rent of both real property and the personal property. Real property acquired on June 10th, 1987 cannot include with any of the interest tenant into the common or other similar interest in it or any direction interest. 501c26 state-sponsored high-risk health organization coverage organization. High-risk health or coverage organization. A state-sponsored organization established to provide medical care to the high-risk individuals should apply with the letter of recognition examples for the federal income tax under Section 501c26. The qualified exemption organization must meet the members of the organization establish state exclusively to provide coverage of medical care of the nonprofit basis high-risk individuals who are state residents and can provide with coverage either by the assuring issuance of the established entering the arrangement with the Health Maintenance Organization HMO. The state must determine the composition membership of the organization, the part of the net earnings of the organization inured with the benefit of any private shareholder individual, high-risk individual, their individual spouse, and qualifying children who become the pre-existing medical center condition can't get medical coverage for that condition through the insurance they have an HMO. Can't get coverage for the condition only at the rate was substantially higher than the rate of the same coverage of the state-sponsored organization. Alright, 501c27 qualified state-sponsored worker compensation organization. 501c27A pre-June 1st, 1997 organization. A state-sponsored workers' compensation reinsurance organization shall apply letter of recognition exemption with the federal income tax under statute 501c27. To qualify exemption, any membership organization must meet all the following requirements that were established for the state before June 1st, 1996. Exclusively reimburse the members of the loss of the under the workers' compensation to the state required the membership of the consists all the members who issuing the insurance for the covering of the workers' compensation loss in the state, all persons, government, and needs to self-insure against losses. It operates the nonprofit organization return surplus income to the members of working compensation policy holders on a periodic basis and reducing the initial premiums on the anticipation investment income. 501c27b. The organization formed either December 31st, 1997, an organization including the mutual insurance company can qualify the exemption if it meets all the following requirements as created by the state and law organized operated under the state law exclusively to provide workers' compensation insurance required by state law, and state laws provide with significant disincentives if the employers fail to purchase such insurance and provide related coverage in the incidental workman compensation insurance. It provides workman compensation insurance to any employer in the state with their employees in the state and temporarily assigned out of the state would seek for such insurance and meet the other reasonable requirements relating to the insurance. The state markets a financial commitment to such an organization either exists standing with the full faith of the credit with the indebtedness of the organization providing initial or operational capital organization. The assets of the organization revert when the state upon the dissolution of the organization is permanently dissolved under the state law. The majority of the board of directors oversight body of such organization are appointed with the chief executive officer over the other executive branch officials by the state and state legislature or both. 501c9 co-op health insurance issuers. Insurance include the qualified nonprofit health insurance issuers who have received a loan or grant under the co-op program under this section of the code. Alright, new guidance for IRC 501c9 qualified nonprofit health insurance issuers. Alright, service section 501c29 is adapted to the code section 1322 H1 Affordable Care Act, provided with an exemption qualified nonprofit health insurance insurers have received the loan with a grant with the center of the Medicare for the medical services. The co-op program for the program that meets the requirements of Section 1322 Affordability Care Act and any of the loan agreement within the Centers for Medicare and Medicaid Services. The co-op program provides the loans and repayment grants for the creation of the members governed by the qualified nonprofit health insurance issuers that will operate with a stronger consumer-focused and qualified health insurance plan. Notice 2011-23, 2011-13 IRB 588 discussed requirements for the tax exemption. The qualified nonprofit health insurance issuers described new Internal Revenue Code Section 501c29. IRS Notice 2011-23. The notice provided the guidance for the annual filing requirement of the organization that intended to apply the recognition Section 501c and the 29 status revision procurement 2015-17, 2015-7 IRB 599 sets out the procedure for issuing determining letters ruling exemption status to the qualified nonprofit health insurance issuers, provided with the guidance of this effective date of exempt status revision procurement 2015-7. Alright, general requirements for exemption under the 501(7) annual filing report. In general 501(c)(29) apply for the certain organization receiving the following loans to provide help with the grants under the co-op program. The organization will qualify to obtain exemption under the section 501(c)(29) only if the organization has received the loan repayment grant under the co-op program that complies with the requirements for the co-op program and the agreement of this CMS. Organization applied recognition of the exemption no matter the organization not earning the individual benefit of the private shareholders. Individual exemption organization is required for the section 11322C4 of the Affordable Care Act to use the profits, lower premiums, improper the benefits, improve the qualifying health care, develop the members. Non-substantial part of the organization activities involved the attempt to influence the legislation. The organization does not participate in intervene with the political campaign. Its revision procurement of the 2015-17 completes the instruction of the tax billing exemption applications. There are additional guidance for the aspect of 501(c)(29) organization. Organization claiming exempt status under section 501(c)(29 exempt the filing application for recognition exemption should get the following form 990 to return organization exempt status income tax indicate that the return is not yet being recovered received a determination letter in addition to the general information required in form 990. These organizations must report certain information regarding the required reserves. Chapter 5 Excess Taxes.